Now, on the subject of appeals, what the public don't appreciate generally is that an appeal is not a retrial. There is no jury at an appeal. It is 3 senior judges sitting in the Court of Criminal Appeal in London, and their decision is this. There is one test and one test only. Was the conviction safe? Or did something go wrong with the trial process to such an extent that it gives them a feeling of unease that the defendant, or the appellant as he then will be called, would have been acquitted or might have been found not guilty of the trial had this matter not gone wrong. It is no use appealing on the basis, I happen to be innocent. That is not a ground of appeal. Or, well, maybe I shouldn't have given evidence, but I did, or vice versa. Or, I should have called this witness, but I didn't. The court is not interested in those grounds of appeal. If fresh evidence comes to light after the trial which was not available at the trial, that can be a ground of appeal, but the fresh evidence has to be of such a weight that it might have made a material difference. It cannot just be the fact that somebody has returned who was abroad to say you're a nice fellow. That's of no interest to the court. Of course, for example, if an alibi witness returned from abroad and didn't know you were on trial for murder, by way of example, the court would allow his evidence to be called to consider whether it makes a material difference to the verdict. As regards appeals against sentence, it is no use appealing on the basis that some judges might have given you a lighter sentence. Again, the court's not interested in that. You have to show that the sentence was manifestly excessive, which means that it's clear on the face of the papers that you were sentenced to far too long and that a reduction should be made.